So long story short, the court issued a dramatic ruling that Hillary Clinton be deposed by Judicial Watch directly, and that he found her prior statements to be under oath, which were in writing, to be unhelpful. So that testimony was supposed to take place by May, I think 15th or 16th. Now, the coronavirus may have caused some delay in that, in theory, in the end, but that wasn't what was going on now, because Hillary Clinton filed what is a really desperate legal motion. It's called a writ of mandamus, essentially suing the court, going to the appellate court and telling the appellate court that you got to stop the lower court from doing this. It was an abuse. And I have an indisputable right not to testify. That's right, an indisputable right not to testify. So, that as a former cabinet official, 9 years out now, that she can't be bothered to testify, that the court needs to step in. And so this is completely out there in terms of any legal argument. And so we had to file our opposition on Friday. But also, guess who else filed an opposition? The State Department and Justice Department. I mean, they didn't want this questioning to go on, but even this gambit by Hillary Clinton was too much for them. So you had the State Department, Justice Department, which had tried to stop her questioning, coming into court and saying, we don't support Hillary Clinton's mandamus motion because it's not appropriate. So, and our brief is just fantastic. It was written by my colleagues, attorney colleagues, Ramona Kotka and Paul Orfanides. I'm sure other lawyers had a hand in it as well. Ramona, has been leading this case since the beginning, and we argued that Clinton and Mills, Cheryl Mills, her chief of staff, who thinks also evidently she's too important to testify. She's a former chief of staff. It's ridiculous. We argue that Clinton and Mills must demonstrate that they have no other adequate means of relief, which they failed to show. Also, Clinton and Mills do not demonstrate that the district court's order was a judicial usurpation of power or a clear abuse of discretion, or that Clinton and Mills, again, have a clear and indisputable right to a writ. In fact, the district court reasonably concluded that Clinton's previous explanation for using a personal email server are cursory, incomplete, and seemingly at odds with what discovery has yielded to date. Judicial Watch also argued that Clinton and Mills are trying to avoid their deposition testimony by relying on their status as, quote, former high-level government officials. They don't offer a single case from this court or any other holding that former high-level government officials should not be required to follow regular appellate channels to challenge a discovery order. Particularly in Mills' case, Judicial Watch notes they identify no case in which a court entertained a mandamus petition to stop the deposition of even a sitting cabinet member's chief of staff. Frankly, if she were in the cabinet, we'd still be able to depose her under the law.
Thanks for tuning in. Be sure to subscribe to our YouTube channel to catch all the latest news from Judicial Watch.